from observation of how things transpired the rest of this week. They will be joining as we go along. May we all please mute our microphones. May we all please mute our microphones before we begin. I'd like to first start off by, on behalf of ESCOM, apologizing for us not having a session last night. I was not able to find a venue without load shedding last night. So I apologize once again to everyone. We are going to try and do as much as we can today to try and catch up. I have requested Zuki to give us slightly more time, and I don't know if she has agreed to that. So I'm just going to wait until she responds, and then we will see how far we can go tonight. At our last session on Wednesday evening, we finished off the defendant actions. Now we are going to deal with preparing for trial. Remember now, an action or the summons procedure is where the parties will lead viva voce evidence and call witnesses to lead such evidence. We're now going to get to the actual trial stage itself to see how practically that takes place. Zuki, there are some comments on the chat. If you can please assist the learners with the students with the modules that are outstanding. We will check later on whether that has happened. But for now, we are going to look at preparation for trial itself. How do you prepare for trial? First of all, when a matter is trial ready, in other words, it's ready to go to court now for the hearing of evidence of each party, the registrar of the regional court or the clerk of the district court in the magistrates court issues a notice to both parties, both the plaintiff and the defendant. Tell them that the matter is now trial ready and you may proceed to prepare for, you may set the matter down. I see a strong worded message by Dimakatso on the group here for Zuki. Can we just hold on for a few minutes, please? So after the registrar has sent out the notice to the parties that the matter is trial ready, it is the plaintiff's duty to deliver a notice of trial, a set down of the trial for the number of days required by the parties to conduct the trial. The plaintiff has a duty to do so, to set the matter down within 15 days after the pleadings have closed. The defendant may do so after 15 days, within 15 days of pleadings closing, if the plaintiff has not done so. And that notice must be sent out to the other party at least 20 days before the date of trial. Now, the plaintiff as dominus litis has the first choice to set the matter down after receiving the notice from the registrar or the clerk of court. But if the plaintiff has not done so, the defendant has a similar duty to set the matter down. Previously, a party could request further particulars from another party. In other words, the plaintiff from the defendant, or the defendant could request from the plaintiff particulars of claim, further particulars of claim. That has now been done away with, because in many instances it merely became a fishing expedition by one of the parties to get information which is not relevant for purposes of the trial, and to get evidence from the other side without wanting to prove that evidence in court. Rule 16 was therefore amended to provide for further particulars only for purposes of preparing for trial, and no other reason at all. Now, in preparation for trial, one of the important steps that the parties must take is that of discovery of documents. So discovery is the process whereby a party would disclose to another party the documents or tape recordings that that party intends to use at the trial. The party must fully disclose the documents and tape recordings. The meaning thereof has now been extended to include whatever other electronic means or digital means the documentation or information may be contained in. And Rule 23 of the Magistrates Court's rules provides for the discovery procedure. First of all, the party seeking discovery from the other party will send a notice in terms of Rule 23(1), requiring the other party to disclose on affidavit, by way of affidavit, within a period of normally 20 days, all the documents and tape recordings they intend using at the trial. That party that was therefore required in terms of Rule 23(1) must then, within 20 days, respond by filing a discovery affidavit in which that party discloses all of the documentation in its possession, mentioning the documents by name, specific names, listing them, as well as the documents that are privileged between the attorney and client. And those documents, a party need not explain why the documents are privileged, but only needs to mention that the other documents in my possession, in my attorney's possession, are documents which are privileged between the attorney and the client, or the attorney and the advocate. They may be opinions or memorandum on advice by the advocate to the attorney. If a party does not comply with Rule 23(1) notice to file a discovery affidavit, the party requested discovery may compel that party to make such discovery. And that party will bring an application to court to compel the other party to discover the documentation required or to make discovery. Upon which, if the other party does not, for whatever reason, oppose the application brought by the one party, the court may grant an order compelling the other party to make discovery of the documents on oath. And discovery is always made under oath. It is not made by way of notice. It is made under oath. In other words, party disclosing the information or the documentation must depose to an affidavit in which they disclose the information. And an affidavit, as we all know, is made under oath and has to be truthful in all respects. Both parties, the plaintiff and the defendant, have the right to discover documentation for purposes of trial, and the rules would apply similarly to both parties in respect of such discovery and failure to do so. In further preparation for trial, especially in trials where medical evidence will be required or called, a party who wishes to introduce such evidence has to make use of the procedure provided for in Rule 24 of the Magistrates' Court Rules. And there it is provided that the party requesting such medical evidence must send to the other party a notice in terms of Rule 24(9)(a) to notify them that they intend calling this expert witness. In addition to that, when they so notify the other party, they also have to notify the party that they intend to, the witness is going to testify on a written report or opinion. And that report has been summarized in terms of Rule 24(9)(b). And a summary of that report must be, or of the evidence of that expert witness must be attached to that notice. Now, when a party in a claim for damages or compensation in respect of bodily injuries is before court, Rule 24 also gives the opponent of that party an opportunity to refer that claimant or person to a medical expert of their choice. And the reason for that is so that that medical expert can examine that person, that injured person, as well as their injuries, and then in order to compile a report on that person's May I please request that we do not request Zuki on this platform to respond to emails. And so we can concentrate, please, on the business at hand for today. It's very distracting to have to see on the chat now. We are now dedicating our times to emails which are not being responded to. Zuki has said that please send any grievances to Mr. Malema, who is the school principal. Can we please now Just respect that request. Thank you. When a party then requests another party to make itself, him or herself, available for such medical examination, they must do so at least 15 days before the date of such examination. And after they've made the written request via notice, they will, the party so being requested will have a period of time before the date of the examination to either object to the examination, or if they do not object to the examination, notify the other side that they will comply with the request, and on the date, and especially at the time at which the medical expert will respond to the notice in terms of the examination. If the other party objects to being subjected to a medical examination by the expert witness of the other party, that party must do so in writing and state the grounds for so refusing. But where the party agrees, but for some reason cannot submit itself for such examination on the date and at the time requested by the other side, that party may suggest alternative times or dates on which they may be available for such medical examinations. In some parts of our country, we have limited numbers of expert witnesses in respect of certain medical disciplines, and the medical experts are found in other cities or other centers or other parts of the country or provinces. Adequate arrangements have to be made by the party requesting the medical examination, such as transport, accommodation, and so forth, to make the person's experience as little as possible traumatic for that person. Because and I've seen this myself, when a person has been injured and has to travel extensive distances, person is already at a disadvantage as a result of such injuries, and it's more stressful on that person to now have to travel long distances and for many hours in order to subject themselves to a medical examination. So by all means, try to find a medical expert that is close to where that person is, to cause them as little stress as possible. If it appears that the state or condition of any property, whether it's movable or immovable, may be relevant with regard to the decision of any matter at issue in an action, a party wishing to inspect such property must give the other party notice, not more than 15 days before the hearing. to inspect that item or that property. In some cases, it is called an inspection in loco. For instance, if an accident happened at a specific venue or scene or location, then the parties may go to inspect the property before. On the date of trial, presiding officers, magistrates may also request, in order to understand the issues much clearer, to inspect the item or the property in question. If it's immovable property, they will obviously have to travel to where the property is situated. Still in preparation of trial, a party may tender in evidence any plan, diagram, model, or photograph which it intends to use at the trial, provided that party invokes the provisions of Rule 24, Sub-Rule 10. In other words, once again, you must give notice to your opponent that I intend using this plan, photograph, sketch, model, or diagram in support of my trial. And upon receipt of that notice, which will be accompanied by the sketch, model, diagram, photograph, or plan, the other party who receives that notice with those items has the opportunity to object to the admission of those documents in evidence. And when that party so objects, and the court does accept the admissibility of those documents at the trial, the party who objected may be ordered to pay the costs of that objection. So there is a warning to parties who wish to object to anything without merit. If your objection is without merit, you will be visited by the magistrate with the displeasure of the court, because it was a total waste of time to object to something which is not worth objecting. And where a party does not object to the admissibility of any of these items, those items will at the trial be admitted into evidence without the party introducing them, having to prove those documents in court. And it also saves the court a lot of time. It means a lot to the court when the proceedings can be curtailed without unnecessary objections and wasting of the court's time. In addition to Rule 24, as we've just spoken about it now, a party or parties preparing for trial have to take further steps to get their matter trial ready. And one of those steps is to issue subpoenas for your witnesses. Now, even though you've consulted with your witnesses, they've given you their undertaking that they will come to court on the day of trial. Believe me, this will happen to you, and it has happened to me on a number of occasions. Your witness simply does not come to court. You phone them the day before trial, you speak to them to put them at ease as you have prepared for trial, but on the day of trial, you will find that there is a no-show. Either they got cold feet, or nervous, or terrified, or something, but you try to call them, their phone is on voicemail. You send someone to look for them, you cannot find them. and your worst nightmare will become real on the day of trial when that happens to you. So it is imperative on you to even issue your own witnesses with a subpoena. And a subpoena is a document which warns a witness to come to court. And if that witness fails to come to court after having been served with a subpoena, the court may issue an order for the arrest of that person. And they may face a fine of up to 300 Rand or even up to 3 months imprisonment for failing to come to court. And that subpoena must be issued at court at first and then taken to the sheriff to serve on that witness. And a subpoena may contain the names of up to 4 people. In other words, up to 4, you may witness up to 4, you may subpoena up to 4 witnesses in one subpoena, as long as their names appear on the subpoena. If you have more than 4 witnesses, use a second subpoena. Put as many as 4 names on there as well if you have that many witnesses. But provision is made for you to subpoena a witness to come to court. If you want a party to bring a document to court which is not in your possession, let me make an example. You are appearing for the Road Accident Fund in a claim for damages, and you want the police officer to come to court to testify, the police officer who took the accident report, who took the measurements and drew the sketch plan to come to court to give evidence. But the evidence and sketch plan are contained in an accident report, which is in a docket. You then issue with the registrar or the clerk of court a subpoena duces tecum. Now that merely means it's a subpoena for someone to bring a document to court, or any instrument or any object which will be used in evidence in court. Now, many parties, or sometimes one party, will try to delay a trial from going to court, or an action from going to trial. And they will be evasive, obstructive. They will not want to attend a pretrial conference. They will not want to comply with discovery. And there already you can see from their conduct that they are trying to delay this matter from going to trial. This is then the point at which a party who is frustrated with this conduct by the other party may approach the court by way of a notice, serve that notice on their opponent, saying to them, we are now going to request the magistrate to call a pretrial conference at which we will identify the issues that are admitted and the issues that are in dispute in order to get the matter ready for trial. The magistrate, through the clerk of the court or the registrar's office, will then issue a notice to the parties to attend a pre-trial conference on a specific date at a specific time and at court, normally in the magistrate's chambers or in open court if there is a court available. And the reason for that is for the magistrate to assist the parties to simplify the issues, and that way narrow the issues in dispute that are to be determined in the trial. It saves the court time. It saves the parties time as well. And at that pretrial conference, Some of the issues that are looked at are whether any of the pleadings need to be amended, whether there are any admissions by one party or any or both parties, and any documents that may be admitted. The contents of those documents may be admitted to avoid unnecessarily having to prove those documents during the trial. Also, if there needs to be a limit of the number of expert witnesses to be called, some parties may call more than 1, 3, 5, sometimes 10 expert witnesses. And holding a pretrial conference will also look at the necessity of calling all of those witnesses. For instance, in a claim for loss of support or loss of earnings, there is an industrial psychologist report. There is also an actuarial report regarding the loss of income. If the contents of the industrial psychologist's report are not in dispute, it may not be necessary to call that industrial psychologist as an expert witness, because the contents of the report are admitted. And that is, at the pretrial conference, what is sought to be done, to curtail the issues, to limit the issues, and to reduce the issues so as to reduce the number of issues that have to be proved in court at the trial. And you may find that the trial that would have taken 5 days because of a pretrial conference can now be reduced to possibly 1 or 2 days even, because the issue in dispute may turn on only one point. Another issue that is normally canvassed and which is important at a pretrial conference is whether any of the parties wishes to make an offer of settlement. Where the plaintiff sues the defendant is asked if it wants to consider settling the plaintiff's claim. And at many such pretrial conferences, matters have been settled because that one crucial question was asked. Do you not intend to settle this matter? Yes, actually, we do intend to settle the matter. We were hoping to go to court to do that. But since you've asked the question here, yes, we'd like to settle. We concede that we do not have a defense and we want to settle the matter. And on the date of trial, we can just go to court with an order by agreement. So a pretrial conference can assist in many ways to bring the matter closer to finality. Now, Rule 27 provides for a number of actions which a party may take. If for whatever reason the plaintiff decides to withdraw the action against the defendant, the plaintiff must do so in terms of Rule 27 and by way of a notice. Plaintiff must serve a notice on the defendant, to say, I am withdrawing this action against you, and I am tendering the costs of withdrawing. It is trite law that where a party withdraws a claim or an action, that party must tender the costs of the other party, legal costs of that other party. When reading these notes, you will notice that I make reference to rules, to rule numbers. Those are the rules in terms of the Magistrates Court rules. And you must refer to those rules at all times. Rule 27 also provides for the dismissal of any claims or any actions. Similar to withdrawals, where that happens, the rule is that the party that has had dismissed their claim must tender the costs of such dismissal. The parties, as I've indicated, may decide at the pretrial conference to settle a matter. And where the matter has not been awarded a trial date yet, allocated a trial date yet, the parties may bring an application or rather the parties may settle the matter before such date and then only go to court for purposes of making that settlement an order of court. If a party also wants to abandon part of their claim, if you remember on Wednesday evening, we spoke about abandoning a claim where the jurisdiction of where the claim exceeds the jurisdiction of a court. That abandonment of that particular claim is made in terms of Rule 27. Also, if a party wishes to abandon any exception or a defense pleaded by that party will do so in terms of Rule 27 of the Rules of the Magistrates Court. Right, that concludes our trials for now, our preparation for trial. We will now move on to application proceedings. But before we do so, are there any questions?
Yeah, me, the boring one. May I ask a question?
Certainly.
Yeah, in terms of settlement agreement, now suppose there's a settlement agreement between two parties and it is not made an order of court. All right, so they decided to settle out of court. Settlement agreement was signed, and every bit of the settlement agreement was honored in time, in full. Okay, no issue there. So my question is, what happens in a case where the other party defaults on the settlement agreement 2 or 3 months later? Can it at that stage be made an order of court? That's my first question. And my second question is a settlement agreement a liquid document? In other words, can the plaintiff actually use a settlement agreement to go straight for a provisional sentence? Thank you.
Good questions. If a party does not comply with a settlement agreement, and if that settlement agreement is not without prejudice, then the party affected by the default of the other party may apply to court to have that settlement agreement made an order of court. Of course, there has to be notice of that application, which has to be done on notice and by way of affidavit, in which the party sets out the reasons why it is applying for the order to be made a settlement, an order of court, the settlement to be made an order of court. And there has to be notice on the other party of such application going to court. And if the court is satisfied that the agreement, the settlement agreement, was indeed breached by the other party, it may order compliance with the agreement. Hopefully that has answered your first part of the question. The second part of the question, if a settlement agreement contains an amount of a claim agreed upon between the parties. And if that settlement agreement is not without prejudice, then it is a liquid document for all intents and purposes in terms of provisional sentence. And you may make use of that document when you are instituting provisional sentence proceedings against a defendant. I hope I've answered your question satisfactorily.
Very satisfactorily, thank you. And Advocate, may I take this opportunity just to ask one very quick question regarding jurisdiction?
Yes, certainly.
Absence yesterday, some of the colleagues were actually debating this. So the question is, if I decide to go ahead with an action and sue a defendant for 175,000 rand, right? That is within the jurisdiction of the magistrate's court.
The district court, yes.
Yes, the district court. The defendant decides to put in a claim in reconvention, a counterclaim for 650,000 rand. Does that go out the jurisdiction of the magistrate's court?
Well, the jurisdiction was already established with the first claim of 175,000 rands.
Right.
If the defendant then responds by way of a counterclaim of 700,000 rands,
yeah,
or any amount above 400,000 rands,
yeah,
it is the plaintiff's duty to object to the jurisdiction of the court in respect of the limit. But it does not automatically. It also does not automatically give the court jurisdiction in terms of the monetary value.
Yeah, I understand. But can a counterclaim of that magnitude then result in the jurisdiction of the regional court or the magistrate court then not applying or not being relevant because of the quantum of that counterclaim?
No, because the plaintiff would have to consent to the quantum. And if the plaintiff has not consented to that amount of 700,000 rands or anything above 400,000 rands, then they can successfully raise lack of the court's jurisdiction to entertain the counterclaim.
Understood. Thank you very much.
My pleasure, sir. Okay, Emily has just reminded me that in our previous class, I said I would go and look into the distinction between offer and tender. This was a question raised by another candidate. All right, I actually have done that, Emily. And the payment tender is the method by which a payment was received. Payment implies an acceptance and appropriation of that which is offered by one party to another, whereas a tender is the act of offering that which is admitted to be due and owing, but which is not accepted by the creditor. The gentleman who just spoke a few minutes ago made the perfect example of his case where a tenant had not paid the money, had tendered the money, payment of the money to his attorneys and not to the plaintiff, because there was a dispute between the parties. I don't know if I've made that clear. So a tender, there's a difference between a tender and a payment in that respect. You can just indicate if I've not responded adequately. Whose hand is up? You may speak. Oh, Pasha.
Oh, thank you, Advocate. Can you hear me?
Yes, sir.
Yes. My question is with regard to Rule 22, set down of a trial.
Yes, sir.
Because we have two grace period there. We have the 15 days, which is which the plaintiff has to adhere to.
Yes.
And we have the 20 days. I believe the 20 days it's meant for the defendant who will be responding to the notice that will be sent by the plaintiff. Now, my question is, advocate, during the time when we were dealing with default judgment, the issue of time frame was discussed under the matter of Santam Ltd versus Bamba, whereby the attorney or the plaintiff was served a day before the due date with the plea, but the defendant submitted the document with the clerk of the court a day after. Now, my question is, with regard to the set down of the trial, if maybe it happens that the plaintiff sent the notice maybe after 15 days, will that notice be defective, or will the court give the plaintiff a condonation for being late with 1 day? But vice versa, the defendant, if he can reply to the notice of the plaintiff maybe after 21 days, how will the court treat the matter there? Versus, or as compared to the one of Santam Ltd, whereby the court questioned the attitude of the attorney for not disclosing to the court the fact that, in fact, the defendant submitted on time on our side, but he failed to submit on time when the document was delivered to the clerk of the court. Thank you, advocate.
Thank you for your question, sir. And it's a good question. When a party sets a matter down, the rule does specify that the plaintiff must deliver that notice within 15 days after pleadings have closed, right? And that notice must also, if there is already a trial, and that is where there is no trial date yet, right? It's 15 days where there is no trial date, but 15 days after the pleadings have closed. Now, if that notice, if there is a trial date, that notice must be delivered at least 20 days before the actual trial. Now, where, for whatever reason, the notice is given after the 15 days after the pleadings have closed, or the notice is given 22 days or 18 days before trial. If no party raises an issue with that, and if the court does not have a problem with that, because courts are all for progress, and a party who is prejudiced by the short days that within which it was served must raise the objection with the court. And if that party does not raise an objection, it means silently that that party has condoned non-compliance with it. It's a different story if it is done 1 or 2 days before, or 3 or 4 days before, and a party does raise an issue with it and does say, but I'm prejudiced because the rules say you must give it to me within 15 days after pleadings have closed. You've given it to me after 30 days of pleadings being closed, or you've given it to me 10 days before the day of trial. I'm not satisfied. And the courts will, in that case, visit their displeasure upon a litigant who does not follow the rules and gives short notice by ordering them to pay an appropriate costs order on that day. I hope I've answered you satisfactorily, sir.
Indeed, indeed, advocate. Thank you.
Thank you for your question. Right, quick question. Tabo has a quick question. In an MVA matter where we filed a Rule 2549 A and B notice, which contained the incorrect details of the plaintiff's vehicle, incorrect amount claimed, as well as incorrect details of the assessor, can the plaintiff's attorneys withdraw that notice and file a new Rule 249 A and B or amend the notice? What is the best option here in withdrawal or amendment? Withdrawal, sir. I would say withdraw that notice completely and file a new notice with the correct information in it. Because amendment is in respect of pleadings only, if you remember. You can't amend a notice by way of a notice of amendment, an amendment by way, sorry, a notice by way of a notice. So you can only correct it by withdrawing the incorrect one and filing a correct notice. Anthony?
Yes, sir. Sorry, Advocate. I just want to go back to the judgment we talked about earlier. So in the event that the notice of intention to defend was filed late and you proceed with default judgment, as the attorney did in that instance.
Yes.
And then you lodge the application for default judgment. Then afterwards, the notice comes to your attention. Should you then inform the court that the notice has come to your attention after you filed it? Or is that a different scenario?
Okay. Now, attorneys and advocates are officers of the court, and they are expected to at all times be honest towards the court. And they must disclose whatever information there is available in a matter. Now, in this Santa matter, the attorney for the plaintiff who had applied for default judgment knew that he had received a notice of intention to defend a day late. And you must remember, in that judgment, in that appeal judgment, the court also said that where a litigant knows, a legal practitioner is aware that something has taken place, there is a duty on that legal representative to make that information known to the court. That legal representative kept that information away from the court. You must remember also that the notice of intention to defend, although it was served on the plaintiff's attorneys, it was not filed in court. So the court was not aware that it was now defended. It was only when the court was told that by the defendant, but we are defending this action, by the way, and we filed a notice of intention to defend. We've just not filed one in the court file, and that's why you don't know, Mr. Magistrate, that this matter is being defended now. And I think it turned more on the fact that the attorney for the plaintiff did not disclose to the court that the matter was being defended, despite having been filed with it. And the court also held in that case that even though the notice of intention to defend was filed one day late, the intention was always there by the defendant to defend the action. And the court looks at that. Are you satisfied with my response?
Yes, thank you, Advocate. And then, so if we hinge on the fact that the defendant's intention to defend is the important factor here, I think if I'm understanding it correctly, the rules, it says that should the defendant file it between this time and the time of default judgment being granted, so between the filing or the issuing of the default, the application, and to the granting of the order, then they must tender costs. Is there any obligation on the plaintiff during that time, if the other party refuses to tender the cost, to forego that default judgment?
Or you mean to proceed with the default judgment because the other party refuses to tender the cost?
Yes.
I would suggest that the plaintiff proceeds with the default judgment, withdraw it in court, but ask the court to make an order for costs. Then the parties will have to, at that hearing, argue the issue of costs, and then the defendant will have to tell the court why he or she does not want to tender the costs.
Okay, thank you, Advocate.
Pleasure, sir. Right, we have La Rosa Mkize. Thank you for joining us late. I would suggest you read the other messages above there. We said that we will not be discussing any of these issues regarding meetings and emails with the principal on this forum. For purposes of progress, please, everyone, let's keep this format, this platform open for purposes of our session this evening. Whatever issues you want to deal with, you will deal with. Zetu, that goes for you as well. Any other issues regarding emails and other grievances must please not be discussed on this platform. They are distracting. Thank you. We had previously decided that we will not be dealing with any issues outside of what we are here for today. Thank you. Right, any other questions then? Right, we are now going to start with the application proceedings, or the motion proceedings as we refer to them. We must be reminded here that the rationale here is that if you decide, in order to decide the application proceedings or to follow the application procedure, you have to look at whether it is anticipated that there will be a dispute of fact between the parties in respect of the subject matter. And if you cannot anticipate any or do not anticipate any material dispute of fact on the application, on the matter beforehand, the application procedure is the way to go. But in terms of our law, there are certain proceedings which can only be instituted by way of application procedure. And one example I made was, even though it is in the High Court, is that of sequestration. Sequestration proceedings can only be brought in terms of an application. But there are other types of applications which can only be brought in court by way of application. For example, an ex parte application. You cannot institute an action ex parte for relief that does not perhaps have a respondent, or relief where you do not need to serve on the respondent. The language itself suggests an application if you're referring to a respondent, because you don't have a respondent in an action. You have a plaintiff and a defendant. So Rule 55 applies to application proceedings in the magistrate's court. So whenever you deal with applications, you need to consult the provisions of Rule 55 to know exactly what is said in there and what is provided for when you want to make an application in the magistrate's court. And there you will see it is quite an extensive rule. It is quite lengthy. It has 11 subsections. And there you will find everything to do with an application. As a general rule, all applications in the magistrate's court must be brought on notice, and preferably, and it's called notice of motion or notice of application. and preferably supported by way of an affidavit, also called a founding affidavit. If you like, an affidavit to found your cause of action. There's a very useful book which I want to refer you to, which deals with both the rules and the Act, the Magistrates Courts Act, very extensively. And it's a very old publication which is very reliable, and it's that of Jones and Buckle. You'll see on page 134, at the top thereof, appears the name of the publication, Jones and Buckle, The Civil Practice of the Magistrates Courts in South Africa, Volume 2, 10th edition. There it is stated at page 56, 2, that applications for final interdicts are usually tried by way of action, and that applications, whether ex parte or otherwise, are the exception. Jones and Buckle deal extensively with the rules and the Act, as well as they have commentary on both the Act and the rules, in which they discuss very extensively the leading cases on the legal principles that apply to applications. So, as I've said, every application must normally be brought on notice, but the exception to that is an application brought ex parte. For instance, if you want to appoint someone as a curator ad litem in a matter, you may not serve that application on anybody. Even though the road accident fund may be the respondent in that application, you do not need to serve it on them. In other words, you can move that application ex parte. Ex parte means without notice to a party. And if the grounds set out in your founding affidavit support the application being brought ex parte or without notice, and the court is satisfied with that, then the court will grant the application in the favor of the applicant. So your notice of motion, which is the equivalent, I would say, of a summons, and a founding affidavit will be the equivalent of particulars of claim. And just like in particulars of claim, in the founding affidavit, you will set out exactly in the same way as you would in the particulars of claim, but in the founding affidavit, you will refer to the first person. And an example would be as follows. I, Donovan Pitt, do hereby make oath and say, 1, I am the applicant in this application. I am duly authorized to make this application, and I have the necessary locus standi to bring this application. I am an adult male person residing at number 11, 12th Avenue, Sandton, Johannesburg. The facts deposed to in this affidavit are within my personal knowledge and are both true and correct. The respondent is the Minister of Education. I am bringing this application for the following relief. I respectfully submit that I am entitled to the relief which I am seeking, and I intend to set out the grounds therefore below. In the circumstances, after you've given the factual matrix, you say, in the circumstances, I respectfully submit that I have made out a proper case for the relief sought and humbly beg the Honorable Court to grant me the relief. You will notice that I've just given you an example of how you set out your allegations in an affidavit in support of an application on notice. And you will notice that it is in the first person, whereas in the action proceedings in particulars of claim, you state the facts. You state factual allegations.
I'm good. I just sent you an email in the WhatsApp now after letter. I'm gonna send it down like 20 minutes now, so you can just go through it and then you can just discuss, man. Okay. Okay, sure, man.
Are you done with your phone call, sir? Someone's mic is not muted, and they just made a telephone call to which we also were witnesses. Can I please request everyone, that includes all of us, except myself, to mute our microphones, please? It's very distracting each time to have somebody either talking on the platform. It holds us up. All right. Thank you. In your notice of motion, as well as your founding affidavit, you must cite all the relevant parties, all the respondents and all the interested parties to that particular application. And shortly, you must state in the notice of motion what the relief is that you are seeking against the respondent or the other parties. And that notice must be served by the sheriff on the respondents before the hearing, at least 10 days before the hearing, if it is a normal application. So you must give them at least 10 court days notice before going to court. And we said court days exclude public holidays and they exclude weekends. Now, there is an exception to that. An exception of not complying with those dates is an urgent application. If, for instance, you want to bring an urgent application, before we go there, an ordinary respondent is given at least 10 days notice before the hearing. But in the case of a state organ, it must be 20 days notice to a state organ of an application on notice, an ordinary application. And the exception to that is an urgent application where you want to call the parties to court on an urgent basis for something that needs to be done within a short space of time. And you cannot come to court on the normal rules or the normal time frames. There you will then ask the court to condone your non-compliance with the time frames. And then because the matter is urgent, and then you ask the court to hear the matter as an urgent application. But even there, the Law of Evidence Amendment Act requires that you give the state, an organ of state must be given 72 hours notice at least, and not like other parties. You can give other parties 3 or 4 hours notice of an application. But the state must be given at least 72 hours notice. And that is because of the bureaucratic red tape involved with an organ of state trying to to instruct an attorney to deal with the matter, because in most probability, it will be served on the office of the state attorney. The notice will be, the state attorney's office must now find out who the relevant official is in the department dealing with this matter. And after having found out who that official is, the official must get instructions, or rather must get a mandate from a senior person to authorize or instruct the state attorney to act on their behalf. And in most cases, the state attorney's office will not out of their own oppose the application. They will want to consult with an advocate on an urgent basis. This is already 3 days down the line after having received notice, or 2 days for that matter. Even though the matter is urgent, they will only on day 2 be able to consult with an advocate who is available and they have cumbersome procurement processes to follow. As you can see, there's bureaucratic red tape with regards to appointing attorneys and advocates during such short time frames. And that is the rationale behind the 72-hour notice period in respect of organs of state. And it has been raised on a number of occasions successfully as an objection to parties taking as an organ of state to court on short notice. So on the notice must be the name and the address of the applicant, where the applicant is represented by a legal representative. The legal representative's details must appear thereon. And like with the case of particulars of claim or summons, it is the attorney who signs, or it is the applicant himself or herself. In applications ex parte, in other words, where no notice is served or needs to be served, that the applicant in those applications must observe the good faith when approaching the court for relief. Just remember, the facts will be coming from one party only. And like I made the example of the road accident fund earlier in the curator ad litem application, the court will rely on the applicant's affidavit for a full disclosure of the facts. If for whatever reason it becomes apparent that the applicant, or rather the legal representative for the applicant, was not honest and did not disclose all the facts, the court will frown upon the conduct of such an applicant or a litigant or a legal representative. And the court may even issue an order that the judgment or order be referred to the Legal Practice Council for investigation of the matter into the ethical or unethical conduct of the legal representative who represented the applicant. So it's important to act in an ethical manner at all times. And the magistrate may even visit that litigant, that legal representative, with an appropriate cost order. And one such appropriate cost order may even be an order that the legal representative pay the costs de bonis propris. Litigants do not draft papers, especially where they are represented by attorneys. And the attorney is under a duty to follow the correct procedures and to put in there, in the papers, the correct information and facts pertinent and relevant to the matter at hand. And when that is not done, they call into question the competence of the legal representative when representing the client, giving advice, and drafting the appropriate or correct documentation that is required in terms of the rules. Obvious errors in spelling, figures, or dates do not invalidate any process or notice if those errors do not mislead the court. But if those errors do mislead the court, then those errors must be amended before going to court on those matters. So be careful not to mislead the court by errors in your documents. If the moment you pick up an error and the matter is already before the court, bring it in the notice. Bring it to the attention of the court immediately when becoming aware of it. The court may condone it at that time and grant an amendment on a verbal application. There's no need to bring a substantive application. Remember, we are still dealing with ex parte applications. But where a notice or any process contains an error, the court will require you to either amend it or by way of notice if there is time, or in court upon application by you. Affidavits cannot be amended by notice. In order to correct an affidavit or any information contained in an affidavit, a party must file a further affidavit on application, because there are only specific number of affidavits which can be filed in an application. And they are three: the founding affidavit, the answering affidavit, and the replying affidavit. Those are the only three affidavits permitted in an application. However, if for any reason a party raises new facts, let's say after the replying affidavit has been filed, the applicant has now raised new facts in the replying affidavit which were not in the answering affidavit and which the respondent did not have knowledge of when drafting the answering affidavit. That respondent may then approach the court on application in an application, in an affidavit for leave to supplement the facts by way of a supplementary affidavit. If the court is satisfied, there must be good cause shown, of course, by the applicant, by the respondent in this case, to want to file a further affidavit. And the court will, upon good cause shown by that respondent, grant them leave to file a further affidavit. Many a times when parties have just out of the blue filed affidavits after the permitted number of affidavits had already been filed, the courts did not happily deal with those affidavits. But it is also up to the other party, if it feels that an affidavit was filed unnecessarily outside of the rules, to raise that point, that legal point, by objecting thereto in the appropriate forum and manner. There are instances in which an affidavit may not be required. For instance, in an urgent application, and I've experienced this, the matter was so sufficiently urgent that after having drafted the notice of motion, the applicant did not have time to consult, did not have time to compile a founding affidavit or an affidavit in support of the application. And there, the court allowed the applicant to lead oral evidence in support of the relief sought in the notice of motion. But the court also said, in granting the interim interdict to the applicant, that the applicant must file an affidavit after the fact to support the facts relied upon for the relief in the notice of motion. You will also hear of an application for a trial date. An application for a trial date is a mere notice, and it's not an application per se in the true sense of the word in terms of Rule 55, where you have to bring an application or notice of motion supported by an affidavit. In an application for a trial date, it's merely a notice that says, notice for application of a trial date. Take notice that the plaintiff hereby applies for a date of trial in this matter. Full stop. That ends it there. There's no need for an affidavit. So Rule 55 then makes provision for the following distinct procedures: unopposed applications, right, on notice, opposed applications, and an unopposed application is at the beginning stage when you are just launching the proceedings. and you set it down in the unopposed row, it is an unopposed application for all intents and purposes, because the respondent has not opposed the application. But the moment the respondent files a notice to oppose, of intention to oppose, it becomes an opposed application. And subject to the respondent filing an answering affidavit and the applicant filing a replying affidavit, it will then become an opposed application. We've spoken about ex parte applications, and we've also spoke about applications which may further be divided into those that can properly be decided on affidavit and those that cannot. I made an example of the oral evidence of the applicant. There are also what is called interlocutory and other applications incidental to pending proceedings. You'll find where there's an action pending and one of the parties needs to compel the other party to make discovery. That application to compel discovery is called an interlocutory application because it is done within the already existing proceeding of the action. So there's already an action pending. Or if there's a main application, and whilst that application is pending, an interlocutory application is made to compel discovery. You can bring an application to compel discovery in an application where a party has, in terms of Rule 23.3, requested specific information from the other party, and that party has failed to provide that information. Applications to court for authority to institute proceedings or directions as to procedure or service of documents. This is also called substituted service. It's an application which is brought by a party for a specific order to authorize that party to serve the documents or papers relating to the application or action on the respondent or the defendant in a divorce action by substituted service or by edictal citation. Substituted service may be by advertising a copy in the Daily Dispatch, in the newspaper, by serving a copy on them on Facebook, by serving a copy on them on WhatsApp. Those are all accepted ways of substituted service these days, provided that you make out a cause for it in your papers. Next then is an application for the striking out from any affidavit a matter which is scandalous, vexatious, or irrelevant. That's also a type of application you can bring on notice to the other side that your affidavit contains scandalous, vexation, or irrelevant facts which should not be in there. They may be vexatious, they may be defamatory. You may then bring an application to have those facts or allegations struck out of that affidavit. Then you may also, if you want to join parties to an application who are not party to an application, you can bring an application then to join those parties as parties to the proceedings. Also, counter applications. If you want to now, as a respondent, answer to the application of the applicant, and in doing so, you also want to bring a counter application. You may do so as the respondent by bringing an application. Sometimes you will, as an attorney, be approached by 20 people who were arrested by the same group of policemen who were protesting at the same time, at the same place, for the same reasons, or maybe different reasons. And all 20 of those people having been arrested, you now institute proceedings against the Minister of Police for unlawful arrest and detention on behalf of all 20 of them, but you bring 20 individual actions against the minister. It may be advisable there then to bring an application for consolidation of those 20 cases into one single case so that it's easier and more convenient for the court to deal with that application with those 20 actions against the minister. Funeka, you have your hand up. Okay, Funeka's hand is down. Right. Any questions before we take our break? Okay, no questions. If in an affidavit, in answer to another affidavit, yes, Anthony?
Sorry, sir, to interpose. With the notice, when serving a notice, and you have been provided with an address of the legal representative, and let's suppose that you and the other legal representative, have agreed to electronic service. When you email that document to the other party, does that constitute service, or only upon reply that it was received does it constitute service?
All right. If the other side, if the legal representative Hello, can you hear me?
Yes, sir. Sorry, you cut out for a moment.
Yes, yes, we can hear you.
All right, I'm back. Anthony, did I answer your question satisfactorily?
Sorry, sir. You cut out before you started to answer the question. If
Oh,
you could
okay.
just
Sorry about
kindly
that.
repeat.
Sorry about that. I said if the legal representative for which is your opponent has agreed to service via email, and you send that notice subsequently to them via email, and they receive that notice, that is considered proper service.
Okay, thank you, sir. And if when you have the address of the attorney and they direct you to serve notice there, and you serve notice by way of email and then serve notice on the client as well. If you serve notice on the client instead of the attorney, I guess is my question, does that also constitute sufficient notice, or will it be defective notice on the basis that the client has legal representation and you should have served the legal representative?
Yes, you see, the moment that a client or a party engages an attorney or legal representative to represent them in a case, you do not communicate with them. You communicate only with the attorney, because the attorney as well, when he files or she files a notice of intention to defend or the initiating proceedings, it will state there all documents relating to this matter must be served at the offices of the attorney only. So it will be deemed improper service, provided the attorney, for whatever reason, does not respond, or the attorney, for whatever reason, does not acknowledge receipt of the documents. And of course, where you do have the documents where you do have the contact details of the client. But only as a last resort, where, as I said, when the attorney, for whatever reason, is not capable of being located, or is not responding to any of the notices, and it is important that it be brought to the client's attention, then you may, in those circumstances, serve on the client, but you will also have to file an affidavit subsequent thereto to state that you served it on the client and the reason for serving it on the client.
Okay, thank you very much, sir.
Pleasure, sir. All right, we are now going to take our break, our short 15-minute break, after which we will return with more vigor and speed. Thank you. See you in 15 minutes' time. Right, we are back. Are there any questions before we proceed? Yes, sir.
All right, Advocate. Thank you. I just want to get clarity. I didn't get the response clearly regarding the service via electronic mode, via email. So I just want to check if, I just want to know if whether the proper service is it determined when one is sending the email, and the email, in fact, I send the email to the other party, but I don't receive any acknowledgement of delivery. Will that be accepted as proper service, or will I have to get acknowledgement first for the service to be proper?
All right. The court normally accepts an email with an address, with the correct address on it, as proper service. It is only when the issue of service becomes problematic, or it is raised as an issue by the other party, that the party now says, but I didn't receive notice for whatever reason, because it may have been sent to my email address, but I didn't receive it. It maybe was rejected by the server or anything to that effect. It is then upon the party who alleges or relies upon service by email to prove that they've sent the email to the correct email address, and to which email address was confirmed in writing previously that they will accept email by that address. And lastly, that party who relied on email service has the duty to then obtain a read receipt of that email, or a delivery receipt of that email. And IT technicians, I'm told, are able to produce a receipt to show that the email was delivered to that person, or that it was read by that person. I hope I've answered you sufficiently.
So no, I heard you, Advocate. So it
I hope I've answered you sufficiently.
Yes, but a follow-up. So it means it will be advisable for one to ensure that we track our emails so that we can see if the email has been read by the receiver.
Yes, sir. It will be in your interests to do so.
Okay, thank you.
My pleasure, sir.
Thank you.
Now, in applications, a party is required, a respondent is required to respond to the allegations by the applicant in the founding affidavit by way of an answering affidavit, similarly to a plea in an action, where they will respond to each allegation either by admitting, either by denying, or confessing and avoiding the allegation. In so doing, there will be admissions and there will be denials. And where a party has admitted an allegation, but now wants to change that admission to a denial, that party must bring an application, a substantive application, for the withdrawal of that admission and replacing it with a denial. And in the affidavit, in support of that application, the party so desiring to withdraw the admission must set out fully the facts upon which they rely to support the application for the withdrawal of the admission. So you cannot simply just say, oh, I withdraw that admission and I file here with a denial. I actually wanted to deny the allegation. You must provide a substantive application in which you fully set out the facts as to why you are changing it. You must also remember that the allegations are made on oath, on an affidavit, and because of that, you have to now change it. But it's more about changing an admission to a denial that makes it more sacred, and the need for an affidavit, for an application on affidavit. The same applies in an action where you want to withdraw an admission in a plea. You cannot simply do a notice of intention to amend and file a denial instead of and withdraw your admission. You have to bring a substantive application, such as in this case. So in an affidavit, when you are bringing an application, your affidavit must contain the facts on which the applicant relies in support of the relief in the notice of motion. So there again, as in your particulars of claim, you must be able to tell from the affidavit, the founding affidavit, that there are appropriate allegations in there to establish the locus standi of the applicant. In my example earlier on of what an affidavit should look like, or sound like in this case, I made certain allegations where I indicated more specifically that the applicant has locus standi to bring the affidavit, and that the applicant is authorized to depose to the affidavit and launch the application proceedings. It's also, you may, without having expressly said that you have locus standi to bring the application, you may imply from the facts that you have the necessary locus standi, and it's only where the other party raises an issue that you do not have locus standi that you will then show by way of implication that I do have locus standi. And that was the principle that was founded in Davids versus Labby and others, which is a 1958 volume 2 SA 405, and it's a Cape Division case. That's on page 137 for those of you who are following pages. You must set out facts that the court has the necessary jurisdiction to entertain the application. And in respect of ex parte applications, it's Kaiser, the case of Kaiser, ex parte Kaiser, 1902 TH 165 at page 169. You must make out a cause of action in your papers. Without a cause of action, you have no case. Your facts will normally support your cause of action or show your cause of action. You must also in your affidavit set out the evidence on which you are relying for your relief. Remember, I told you that in applications, your affidavit constitutes your evidence. There's no oral evidence to be led by witnesses, generally. So your evidence must be contained in your affidavit. So your founding affidavit must be as extensive as possible to set out as clearly as possible your evidence. So in order to strengthen your evidence, you must set out all the facts upon which you rely. And there's the case of Mauerberger, I don't know, but anyway, there's a case in which the principle was established in 1948 already, that you must set out all the facts. New matters in your replying affidavit, when the applicant now does a replying affidavit in which the applicant introduces new matters or new facts, they may be struck out. Pontus Trustee versus Lahanas is the case in which it was held that a respondent who was faced with the applying affidavit which introduces new matters, you may apply for those new matters to be struck out, or new facts. The principle is you stand and fall by what is in your founding affidavit. You must make your case out in your founding affidavit. You cannot use your replying affidavit now to patch the holes that were caused by the respondent in their answering affidavit. You have the duty to make your case in your founding affidavit and not the replying affidavit. The person, normally the applicant making the affidavit, must state the source of the information. If it's not personal knowledge, you must state where your source gets the information from, or what your source is, where you got your information or facts. And where it is another person, you must file a confirmatory affidavit by that person to confirm the truthfulness and correctness of the information as provided to you by them. And otherwise, if you don't have a confirmatory affidavit, that will be deemed to be hearsay evidence. There's an exception in urgent applications that hearsay evidence may be accepted in urgent applications because of the urgency and the nature of the proceedings. Depending on that, of course, and the facts in that particular instance will determine whether the hearsay facts may be, or allegations may be accepted. You may only, as a litigant, put in new facts in the replying affidavit if that information only came to your attention after the respondent had filed the answering affidavit. And you must state so in your replying affidavit that at the time of the respondent filing an answering affidavit, the information contained in this affidavit was not at hand. And as a result, the respondent, I hereby consent to the respondent being provided an opportunity to specifically respond to these allegations. In all fairness, the court will support such allegations in a replying affidavit. Where after having filed, now there are 3 affidavits that are allowed in all applications, opposed applications. The first, as I said, is an answering is a founding affidavit, which accompanies the notice of motion. Then the respondent will file an answering affidavit in answer to the allegations in the founding affidavit. The applicant then has a second bite at the cherry and is permitted to file a replying affidavit. Those are the only 3 affidavits that are permitted in an application. If, for whatever reason, one of the parties deems it necessary to file a further affidavit, they cannot merely file an affidavit. The court has to give them permission. In other words, they must bring a substantive application on paper with the notice of motion and a supporting affidavit setting out why it is that they are now filing this affidavit or want to file this further affidavit after the 3 permitted affidavits. And only if they've shown good cause or a good reason why they could not file that affidavit or could not contain that affidavit in the previous affidavits, then the court will permit them or give them leave, grant them leave to file a further affidavit. And also, of course, provided that the application is not opposed successfully by the other party. We've dealt with ex parte applications. I've mentioned interlocutory applications to you. An interlocutory application is an application within an existing legal proceeding. In other words, if there is an application that's pending, and for whatever reason, such as the one I've just made a few minutes ago, where there's a main application in which the 3 affidavits have already been filed, one of the parties brings an application now to file a further affidavit, that will be deemed an interlocutory application because it is inside of an already existing procedure. The same would apply in the case of an action where there is an action pending and one of the parties brings an application to compel the other party to do something or refrain from doing something. That is also called an interlocutory application. Right, now, rescission of judgments. Now, a rescission, the word rescission means setting aside, right? Or canceling something. Now, in legal terms, when we want to cancel or set aside something, we say we are rescinding it. You rescind a judgment or you rescind an order, right? Now, Section 36 of the Magistrates Court Act sets out the various judgments which may be rescinded. And the court may rescind or vary any judgment which was granted by it upon an application by a person. In other words, a party that wants to set aside the judgment. It may have been a judgment of the court in an action, but let's focus on application now. There was an application in which a judgment was granted against let's say the judgment was in favor of the respondent. The applicant is now not satisfied with the judgment. And now wants to bring an application for rescission of that judgment. Let's call it a default judgment. Let's say the plaintiff got default judgment against the defendant. That plaintiff is then able to bring a rescission. I mean, the defendant is able to bring a judgment, an application for rescission of that judgment. A judgment other than a default judgment or a summary judgment has to be appealed by a party and may not be rescinded. We are only referring to default judgment or a summary judgment that may be rescinded. And that party that wants to rescind must give the other party notice, and it must do so within 20 days after obtaining knowledge of the judgment, right? Knowledge. So if the judgment was granted in June of 2021, and it only comes to the attention of the person on the 19th of August, they have 20 days from the 19th of August 2022 to bring an application for rescission. But that application for rescission must be done on notice. So you'll say, this is a notice. I was a party in these proceedings. I want to rescind the judgment. And you set out the reasons why. What are the reasons for, and it must be accompanied by an affidavit in support of that application for rescission. The affidavit will set out your cause of action. And the other party will have an opportunity to oppose that application for rescission should they wish to do so. Or even to vary the judgment. If the judgment perhaps was incorrect, the application must say in which respect the judgment was incorrect and which is the part of the order which they wish to have varied. So in a similar way, a party opposing rescission application will have to file a notice of intention to oppose, will then have to file an answering affidavit. The applicant of that application for rescission will also then have an opportunity to file a replying affidavit. So the provisions of Rule 55 will kick in here again. Rule 49, sub-rule 5, capital A, came into effect on the 1st of August 2018. And in terms of that rule, a debtor or any other person affected by the judgment may apply to rescind the judgment if the judgment debt, the interest thereon at the rate granted in the judgment, and the costs have been paid in full. You've come across the concept of ITC or the Credit Bureau having listed you for a judgment. That judgment, in order for them to remove that judgment, you have to bring an application for rescission. And what's nice about that is it's easy, because if you have settled the debt fully, and you've got proof of payment, you ask the creditor for proof that you've paid up the account. They will provide you with the proof, and then you also ask them for a consent to rescission. And if they give you a consent to the rescission, you then bring an application to the relevant court, and then the court will grant you a default judgment, a rescission of that judgment, which you will then forward to the Credit Bureau, and they will then, after a certain number of days, remove your name from the Credit Bureau as well. And in a rescission application, an applicant has to show the court that, one, they were not in willful default and that the judgment was satisfied, as I've just indicated now. You've paid the debt. And then secondly, thirdly, you can even get a rescission of a judgment. You can even get a rescission of a judgment if you have not paid the debt in full, but if you've made satisfactory arrangements with the creditor, then they may consent to you rescinding the judgment. Okay, Zanele asked a question, who pays for costs for rescission? If successful, normally a party is not entitled to costs if the application is unopposed. But if the application is opposed and the applicant wins it, then the respondent will pay costs of the rescission. But if the applicant brings an application for rescission and the respondent successfully opposes it, in other words, the application is dismissed with costs, costs will follow the cause. Of course, the applicant will have to pay the costs. So the winner takes it all, but only if it's opposed. If it's unopposed, the party is not entitled to costs. The applicant is not entitled to costs. Zanele? Or is it Zetu?
It's Zanele, it's advocate. It's okay, thank you. I've noted that.
Are you covered?
Yep.
All right. Zetu?
Hello, sir. Can you hear me?
I can hear you, Zetu. You may ask your question.
Yes, sir. I wanted to follow up on Zanele's question, and I'm not sure if my question will be outside the scope of the module, but when costs are awarded, in an instance where costs are awarded, who decides the scale and why that particular scale? Let's say, for example, it's party and party costs. How does the court determine that?
Thank you for your question, Zetu. No, it's not outside the scope. It's very much within the scope. The court decides based on the conduct of the parties what scale to apply. In the normal order to award costs on the normal scale is on party and party costs. The court will only grant attorney and client or punitive costs where the conduct of the parties is brought into question or into question. It is only then that the court may consider costs on a punitive scale, unless a party can prove that they did not act unbecomingly.
Okay, so thank you so much. Yes, sir, you have.
All right. Thank you, Zetu. Right, now, the court deems its orders and judgments as sacred and authoritative, and every party required to act in terms of an order or a judgment is required to comply with its conditions or its terms. There comes a time when a successful party comes back to court for the court to complain to the court that its order was not complied with within the given time. The court may, in that case, give an order or a judgment against the party that's in default of its order. It may also give the party an extension of time to comply with the order, but will remind the party of its failure or default by ordering a cost order against that party. So the circumstances will dictate when a party will be liable for costs. And this is where, Zetu, the court may consider the a scale other than party and party costs where a party does not comply with an order of the court. But where a party who has been ordered to act in accordance with the court order fails for whatever reason to comply with that time frame, that party may apply to the court on notice, and in the affidavit set out the reasons why it wants either the period to be extended or set aside completely, and set out the grounds in that affidavit in support of the application, the reasons why they want that order to be, the time frames in that order to be extended. So, but before going to court, the party may even approach the other party and ask them to consent to them not complying with the order. But they must get that consent in writing. And only when that party refuses to give them consent may they approach the court. And this normally happens in, for instance, where a defendant is late with the filing of his plea. Before the expiry of the DAs, the defendant realizes that he will not be able to file his plea within the 20 days, for whatever reason. He may then, his attorneys may then contact the attorneys for the plaintiff in writing and say to them, our client, for whatever reason, is unable to provide us with instructions because he's out of the country. The 20 days expire on Friday. He's only coming back on Tuesday next week. Can you please extend the period within which to file our plea to next week, Friday? In almost every single case, the plaintiff's attorneys will agree because of the good faith within which the request is made. And in this profession, we are very collegial with each other. If you ask for an indulgence and you have a good reason for doing so, it is only respect, it is seen as being respectful to your colleagues. And they, on the other hand, can convince their clients to agree to a reasonable request for an extension in those circumstances. It's very rare that a party goes to court to ask for an order to be given an extension. It's very rare indeed. And it's only in very, very exceptional cases where a party will be unreasonable and refuse. But there are such cases that take place where it's clear that the parties are at loggerheads with each other. The legal representatives are feisty and they are not giving in to each other's whims. Then you will find that parties will not agree. And then there are applications left and right for this type of indulgence, for rescissions, for variations, for extensions, unnecessarily so. And the courts will, when the courts pick up that that type of behavior, that conduct happens, the court will step in and say, no, I don't think your conduct is becoming in this instance, and you were unreasonable in refusing to give them the extension anyway. So I'm going to order you to pay the costs on a punitive scale of attorney and client. So always keep that in mind. Have a look at page 144. Section 32, attachment in security of rent. That is a very, very long sentence, if there ever was one. And it doesn't make for easy reading. But I'm going to try and break it down for you. The landlord, where the landlord is suing a tenant for rent, right? There is a procedure in terms of section 32 of the Act, which the landlord may follow for attachment of the property of the tenant that is on the property in security for rent. And where that is the case, the sheriff may be ordered, the sheriff may seek to attach property to the value of the rental that is being claimed. So the sheriff may not attach property that is worth more than the value of the rental. And the property must also be to the satisfaction that has been attached, must also be to the satisfaction of the clerk of the court, together with damages, costs, and charges. So whoever instructs the sheriff, the landlord in this case, must file an affidavit satisfying the clerk of the court that they will give security for whatever steps have to be taken for any steps which will be taken should the defendant or the tenant suffer any damages. So that's what section 32 says, basically in a nutshell. So because attaching someone's property, more especially a tenant, is a huge invasion of the privacy of that person. Because there may even be a dispute of fact as to whether the tenant is in fact in arrears or owing at all. And for that reason, the section protects a tenant from a landlord who acts rogue, because some landlords will act in a way that is unfair or unreasonable towards a tenant. And the tenant is protected here by section 32 by the landlord having to give security to the clerk of court for any damage to the properties, to the property of the tenant, any costs and charges which the tenant may incur as a result of that invasion of privacy by the landlord. Right, now edictal citation and substituted service. Previously, the magistrates court did not have jurisdiction to grant edictal citation applications, and you had to go to the High Court. But now we have Rule 10, which provides for that. And edictal citation, I can just get the section here. Edictal citation is for the service of process on a party that is not within the Republic of South Africa. It's a cumbersome procedure that you have to do. You have to go through the embassy of that person, the relevant embassy of that person. And it's actually an application which you make to court to get the court to give you permission to serve the papers on the person outside the Republic. That is an exception to the normal ways of serving processes on a person. Substituted service is where you do not know where the person is. They are no longer at the last whereabouts that you know, that you last knew them to be. And as a result, you seek an order to serve them, whatever process, by substituted service, which is once in the local newspaper and also in the government gazette. It's normally on a rule nisi. In other words, it's an interim rule, so you'll be given the interim order to file in the newspaper, to serve, to place in the newspaper and file in the government gazette. Then you will publish it in the newspaper, publish in the gazette, and once you've done both of those, you have to then attach them to an affidavit in which you state that you had served them, you had complied with that order, and these are the copies of the advertisements or the notices, and that you have satisfied the requirement, and then you ask the court to grant you your order for substituted service, and then you can ask for the relief that you've sought in your notice of motion or your action if it's an action. Where a party has taken an irregular step, the other party must apply to court to set aside that step as being irregular. And here are a couple of examples. If a summons has been issued out of a court and that summons has not been signed by the attorney, that is considered an irregular step. The defendant may then, by notice, notify the plaintiff's attorneys that they have issued summons that was not signed. It's an irregular step, and they are given 10 days within which to remove that irregularity. If they do not remove that irregularity, and it's just a simple question of signing the summons and resubmitting it to be served. It may seem pedantic, but it's a requirement of the rules and the act that an attorney or a plaintiff signs the summons before it is issued and served on the defendant. Another example of an irregular step is when the defendant, in response to the summons and particulars of claim, files a notice of exception and irregular proceedings. One notice that is headed irregular proceedings and exception. That itself is an irregularity because you cannot bring in an exception and proceedings for irregular proceedings at the same time. Another example is the clerk of court has not issued a date for trial in a matter, and the pleadings have not even closed. But the plaintiff, on his own volition, serves a notice of set down on the defendant for trial. The matter is clearly not trial ready because there are no pre-trial notices, there was no discovery, and there was no pre-trial conference. And yet the plaintiff merely set the matter down on the roll for trial. There, the defendant will also raise an irregular step notice by saying, Mr. Plaintiff, not in those words though, it'll be to this effect. You have set the matter down for trial on this date, by this notice dated so and so, in which but your notice is irregular in that, number one, the clerk of court did not issue a court date. There was no pre-trial conference to determine if the matter is trial ready. There's no discovery. Pleadings have not closed yet. In that case, I'm giving you 10 days within which to remove this irregularity, failing which I will apply to court to have it declared an irregular step. The plaintiff in that case will immediately withdraw that notice of set down and have to tender the costs of that withdrawal. Remember earlier on we said any party that withdraws any proceedings is liable for the costs thereof, unless they are exceptional circumstances. Now, irregular proceedings are in terms of Rule 60, capital A. Right, we are now moving on to, do we have any questions before we move on?
Yeah, yes, Advocate, is Nasser here again.
Yes, Nasser.
In terms of, I think it was Rule 36, rescission of judgment. Is it a hard and fast rule that one should apply for rescission of any default judgment within 20 days of becoming aware of such a judgment? Is that hard and fast rule? Is that a hard and fast rule? You mentioned it when we spoke about default judgment and under Section 36.
Rule 49, yes. Section 36 and Rule 49.
Rule 49, yeah.
Yes. Rule 49 stipulates, yes, in terms of rule, I would not say it's a hard and fast rule because it says may within 20 days, not must, may within 20 days.
All right.
Does that answer your question?
It answers my question, and just out of interest, just to contextualize it, what actually happened is I was an expat, on a foreign assignment, and in my absence, I was a victim of identity theft. And somebody then went ahead and got credit on my identity card and all of that, and I got to know like a year and a half later that there was a judgment against me, and that application for rescission only happened on my return to the country. And it was well beyond the 20-day period. So that's why I'm asking that question. And the rescission was successful anyway. So I just
was it 20 days of coming to your knowledge, or 20 days of it being of the default judgment being granted?
No, the default judgment was granted. I only got to know of it a year and a half after the default judgment was granted. Yeah. And my application for rescission happened well after the 20-day period when I got back into the country.
Aware.
Of my becoming aware, yes.
All right. All right. It says may, not must be within 20 days.
Yeah,
if you can show good cause why you couldn't do it within the 20 days either, you are and the facts will also be in your support, in your favor, as well as your prospects of success. The courts will not willy-nilly shut anyone out because they've not complied with a time period which says may. It would have been a different story if it said must. Must will imply hard and fast rule.
Right. And the next one, very quickly, as far as judgments are concerned, I think everyone's understanding is that they automatically fall away after 30 years. Is that correct?
Judgments after 30 years?
Yes.
I'm not familiar with that.
Okay.
I'm going to look it up for you.
All right.
I will look it up for you and come back to you later. And just confirm. Yeah, very fine.
You actually covered that when you said if a judgment is taken and you make full settlement, you can get your creditor's consent to rescind that judgment.
Yes.
That's all right. And that those were the two questions I just wanted to clarify. Thank you so much.
All right, but you asked a valid question on whether judgments fall away after 30 years. I would like to look into that as well. I've not come across the issue yet, but hopefully I won't be in practice for that long. But
all right.
But yes, it's a good question. I mean, the fact that you raised it means that it's obviously been asked somewhere before.
All right. Thank you.
Pleasure, sir. Okay, I'm going to deal, you're going to notice that I'm dealing very briefly with some of the topics. That's because I'm touching on what I think is the fundamental principle of the topic. The notes may be more extensive on it. You will be required to read on your own. But for purposes of for progress and for us to be able to deal with every aspect this evening, given our time constraints because of last night, I'm going to try and cover as much as possible. But whatever I cannot get to, please try to read it on your own, those who have not done so yet. And should there be a problem after tonight, if we have not had enough time, sufficient time, I can speak to Zuki or someone to arrange for perhaps some extra time for us to consider whatever we can't finish. But let's try to finish as much as we can tonight. Mr. Patla, your hand is up.
Advocate, can you hear me?
I can hear you.
All right. In fact, it's a follow-up on the matter regarding the prescription after 30 years. In fact, there was a recent judgment. I was trying to locate that judgment. It was a SCA judgment in a maintenance matter, whereby the court outlined the fact that because a maintenance order, it's a judgment.
Yes.
And the prescription cannot fall within 3 years, but in fact, it will fall in under the 30 years period. It will prescribe after 30 years. I was trying to go through the communication that I used to receive the citation of the case, but I cannot be able to get it. But there is an SCA decision. It's a recent decision regarding the prescription period.
Yes.
Yes.
Okay. All right. Thank you for that, Mr. Patla.
Thank you, Advocate.
Advocate, can you hear me?
Yes.
It's not a question, but just a little food for thought here before you close.
Yes, sir.
I'm more into a criminal side because I've had my experience here for 40 years working with the criminal side of things.
Yes, sir.
But it leaves me with the civil in terms of action proceedings and obviously application proceedings. It's a matter of exchanging documents timeously, etc., etc. And it seems to me like more legal practitioners, or rather say advocates or attorneys, will win cases in their support of their clients in terms of complying with the rules of court, in terms of being timeously, in terms of delivering, etc., than fighting the real cause of the complaints in court. Because I think legal practitioners now will wait for the other one to err and then go to court and say you failed us and you failed to respond timeously, or etc. And you did not do a counterclaim on you plea, etc. Because it seems to me from my recent experience, Nazir and I as well, are sharing a lot of our private experiences with the law in terms of civil processes.
Yes.
I've been to court as well not long ago in terms of a grandparent applying for access, or rather you say contact to my grandchild, and obviously through the motions with the family advocate and things. But I was told to bring in evidence. I had statements taken down, etc. But then we go to court. Obviously, now from learning from you, and thanks for educating us on this thing in detail, I had also filled in the form a notice with my affidavit. Obviously, it's now an application. It went to court. It was executed. A service of process was executed served on the respondent by the SEPs. We go to court. But there's no stage where the respondent had made a replying affidavit. I made an affidavit as to outlining my cause and why I'm going to court.
Yes.
But there was no address from the. I just want to know whether the magistrates understand these concepts or whether it's only on book form, because throughout the proceedings, they changed magistrates about 5 times. And every time I had to explain why I'm there, and obviously it went on. And I defended myself in the matter, and he applied for an attorney. Then I think the cost factor came into it. But luckily, he did not have an attorney because I actually withdrew. I got so tired of it
Yes.
that luckily I was not ordered by the magistrate to pay costs because I withdrew, because I eventually won the battle where my daughter had eventually made a pre-agreement to get access and contact with the child like in front of the court and an order of court. But it seemed like the respondent in this matter, when after I served him documents, went to court, he did not even go into the box. He did not even make an answering affidavit to my affidavit. But what I heard, he was so smart. I think he was getting legal advice from the outside, because now I made an affidavit, and lucky for me, I was smart. I did not mention to attack his dignity, so he'll take me on defamation. I said I have witnesses would say this and that and that, but I was denied getting the witnesses to court and things. But he did not even take the stand. The inquiries were held and everything went through, but he did not even take the stand at once because he was a respondent.
Yes.
Magistrates came to a judgment in the matter, and I could see that from what you have educated us in this whole chapter here, it seems to me to be, although attorneys must act in good faith in things, it's more a cunning exercise where they wait for mistakes to take place if you don't serve it timelessly. And I wonder now, if running a practice now, must you be running for one case letters, running to the clerk of the court and register, serving papers, bringing it back, or you have your clerks doing their job, will be a tedious exercise. Thank you, Advocate.
Thank you for those valuable comments. And we learn a lot from other people's experiences, our own experiences. And sadly, you were quite correct when you say that there are attorneys who wait for their opponents to make mistakes and then pounce on those mistakes to delay the process and to bring up spurious applications for irregular proceedings and so on. And that is where the courts, the magistrate, him or herself, must step up and protect the parties, because at the end of the day, it's the parties' cases and not the legal representatives. And sadly, in some cases, it sounds to me that like you went to the family court. In the family courts, they do what they do is they don't follow the letter of civil procedure. Family courts have their own procedures. They may be civil, but they're a mixture of civil and criminal, and they have their own procedures where they act robustly. They don't require parties to file affidavits and things. They will, if the parties are present in court, call them as a witness to testify under oath. And your magistrates, by the way, are mostly trained in criminal work. And that is why that at all magistrates courts, that I've always experienced that there's a lack of magistrates with civil procedure experience. And they often do flout the rules and the procedures because they don't know any better. In criminal court, it's very easy. You don't file affidavits. It's a docket by the police with statements of witnesses. If those witnesses are all in court, investigation is done, call the witnesses, lead your evidence, boom, out. It's like a conveyor belt. They just want to get things done, going and finished, completed. That's unfortunately how it works in that court. But it will take a long time and a long way for us, but we're on our way there, hopefully, to try and change the way things are done in magistrates' courts. I know, for instance, that they are appointing as acting magistrates quite a number of retired attorneys to act in the civil courts, to bring up to speed the civil courts and how things are done there. But thank you so much, Raj, for your question. It was a very valid one, and for your experience as well there. Anthony, do you have a question?
Yes, Advocate. I just want to inquire about the execution process. Say we obtain a judgment against the judgment debtor and then only later on begin with the execution proceedings and obtain a warrant of execution.
How much
But
later?
it's let's say a year later.
Okay.
And it's no longer possible to locate the judgment debtor at said location, at the location last occupied. What would your advice be in such an instance, considering that you need to locate the judgment debtor in order to execute the order, but you cannot locate the judgment debtor even by way of tracing?
I was about to say that you trace, but you touched on that last. What I suggest is in all execution matters, when you want to in respect of a debt or in satisfaction of any damages claim, you want to now execute against that debtor. Do your homework at the stage where you initiate proceedings already. Find out if the debtor has any attachable assets. Find out if the debtor has any immovable property that you can attach. Then you will know at that stage already whether it's worthwhile going after the debtor. But when you sit for a whole year with the judgment in your favor and you don't execute, you are bound to lose your right to execute because of the facts that you've mentioned, that he's no longer available. You can't find him and you can't execute against him. He most probably left the country too within that year. So make sure that when you do execute, you've done your homework before instituting proceedings, and you've obtained everything, and that you move swiftly. That's the nature of debt collection. You've got to move swiftly, because if somebody has not satisfied your debt before you started the proceedings, they are most likely going to jump ship during the time.
Thank you, Advocate. And then just to follow up on that question, should you now not be able to execute the order against the debtor in a manner by way of attachment of
Yeah.
property under a warrant, would it be in conflict with civil procedure to then move for an application for attachment of emoluments and the likes, calling in the judgment debtor to court to verify financial position and standing?
But how are you going to locate him? Because you said you can't trace him. So even for emoluments attachment order, you have to do a financial inquiry. And in order to conduct a financial inquiry, you have to serve him with the notice, the documents. How are you going to serve on him if you don't know his whereabouts? So you won't be able to proceed.
If we have say you have email address and contact details of the individual, and you can apply for substituted service pertaining to the inquiry of the financials.
Yes, then you do a more diligent search. You check if he's got a Facebook page. You check his last known contact details. You can trace him on WhatsApp. You'll be able to find him. If you can, then you apply for substituted service, and then you apply perhaps for other means of serving him if that doesn't work.
Okay, thank you, Advocate.
Pleasure, sir.
Advocate, may I?
Yes.
One quick one. Partly related to what the earlier speaker was referring to, and with reference to attachment. But okay, I'm particularly referring to section 32, which you covered, attachment in security of rent.
Yes.
Now, that section, that very long sentence that you referred to,
yes,
and explained, basically says that the landlord may be asked to provide security for attaching his tenant's property.
Yes.
But isn't there an automatic landlord's hypothek that allows attachment of the property without his providing any security?
There is, but you still, to enforce it, you must still institute proceedings. You can only claim the right once you've proven in a claim instituted in court that you have the interdict, the hypothek.
Right. So despite the hypothek, the landlord could still be asked to furnish security. Is that what the sentence is saying?
Let me make an example for you. Let's say that you tell the tenant as the landlord now that, by the way, I've got a hypothek over your property. You cannot move anything out of here while you owe me. And before you institute proceedings, he packs up and he leaves.
Right.
How do you manifest that hypothek?
Yes, you can't.
Not without
Yeah.
court proceedings. So it's only in terms of Section 36 when you move against that property now that you become obligated to file security for it.
I see.
Because of the drastic measure or the drastic effect that an attachment has.
Understood.
Thank you.
Thank you so much.
My pleasure.
All right. Thank you.
Antonio, your hand. Okay, it's down. Mr. Patla, I'm going to allow yours as the last question.
No, in fact, it's not a question, Advocate. I just wanted to respond to or to give feedback to regarding the case that I referred to. It's Akas versus Akas. It was a decision that was handed down in January by Supreme Court of Appeal
Yes, sir.
Regarding the prescription period. That judgment that prescription period is 30 years as per the decision of SCA.
Yes.
Yes.
All right. Thank you for that, sir. The Prescription Act also Section 11D, so 11A, sorry, also says that a judgment debt will prescribe after 30 years. Section 11A, Roman numeral 3 of the Prescription Act 68 of 1969. It does confirm that. But thank you so much for that, Mr. Patla.
Thank you, Advocate.
All right. Now we are going to deal next with provisional sentence proceedings. When we started with action, we said that you can follow one of three routes. And you may put your hand down, Mr. Patla. And when you do follow, you may either go the way of a simple summons, or you may go the way of a combined summons, which is accompanied by particulars of claim. Someone's mic is on. Raj, I think your mic is on.
Sorry, Advocate.
No problem. And the last one is provisional sentence summons. Now, provisional sentence summons is a drastic measure, and it's extraordinary because you can immediately, you don't have to go the long route of summons, notice of intention to defend, plea, and all of that. If your claim is based on a liquid document, and that is the only procedure that in which you may use a liquid document. A liquid document is the only requirement for you to go the provisional sentence summons route. Any other claim may not be instituted by way of provisional sentence. And we've mentioned on the way a number of examples of liquid documents. A check is a liquid document. And a liquid document is a document which sets out, or it is easily ascertainable as to what the indebtedness is. A mortgage bond. Is a mortgage bond a liquid document? An acknowledgement of debt. So when you institute proceedings by way of provisional sentence, which, by the way, is not a much used procedure. I've been at the bar for 10 years now, and I've not seen a single provisional sentence summons. Before coming to the bar, I practiced as an attorney for 14 years. And in those 14 years, I have not seen a provisional sentence summons. So that tells you that it's as rare as hen's teeth. But it's a procedure that is there, that is provided for by the rules, both in the magistrates and the high courts, by the way. Provisional sentence proceedings are provided for, but practitioners do not follow that route. Hopefully you will invoke these provisions when you start practicing and make use of these proceedings that are available to you. So when a plaintiff sues a defendant by way of provisional sentence summons, the defendant is called upon to immediately pay a sum of money to the plaintiff based on that liquid document. And that liquid document must be attached to the summons as proof. You can't say, I'm relying on an acknowledgement of debt and not attach the acknowledgement of debt. Your claim is defective. Your cause of action is incomplete, if there at all. So in your summons, you will also tell, the plaintiff will tell the defendant that if he or she fails to make the payment, they will be required to appear in court on a specified date, either personally or represented by an attorney, to either admit or deny liability for the claim. Or if it's a mortgage bond property, they must state why the mortgage property should not be declared executable. So can you see how expedient a remedy provisional sentence is? He's not required to file a plea. She's not required to accept. If the claim is not in dispute, which it's so difficult to dispute a claim on a liquid document because it is normally a document which has been signed by the defendant himself or herself. So they are literally hauled before court, and only there will they tell the court they either owe or they don't owe. And if they owe and they have not paid, why have they not paid? So I can already picture a poor defendant who owes this money, who knows he owes this money, receiving a summons and gets to court, or rather the summons tells him he must come to court to come and explain if he owes the money. And if he owes the money, why hasn't he paid the money? If he does owe the money, he will be too embarrassed to go to court. So in most cases, defendants will most probably not even bother to come to court, leading to the plaintiff getting provisional sentence against them because they've not appeared in court. But if the defendant chooses now to defend this action and denies liability, he must either file an affidavit in which he sets out the grounds of his defense, if any. And he must also in that same affidavit, set out either he admits or denies the signature on the document. And if he says that the signature on that document is not mine, but it is somebody who acted on my behalf, but that person, I did not authorize that person to act on my behalf. And now the proceedings change in complexion now. Because remember, we said that this is a form, this is part of the action proceedings. Now it becomes a mixture of an application and an action at the same time, because the defendant has filed an affidavit, and the plaintiff is now given an opportunity to file a replying affidavit. So this animal is changing shape now. It's becoming a hybrid of an action and an application. And based on those two affidavits now filed together with the provisional sentence summons, the magistrate will make a decision as to who is liable, whether the defendant is liable. And if the magistrate refuses provisional sentence, that's the end of it. Provisional sentence refused with costs, if it was defended by the defendant. All right, we've dealt with, so the requirements therefore in order to succeed with provisional sentence are: 1, the plaintiff's claim must be based on a liquid document. 2, the plaintiff must satisfy the court as to the onus which is upon him or her, in other words, the signature or the agency. And thirdly, the defendant is liable to satisfy the court in respect of the onus upon him or her. I beg your pardon, the plaintiff must satisfy the court as to the onus upon him, that it is indeed the document and it's the signatures of the parties. And lastly, the defendant is unable to satisfy the court in respect of the onus upon him, which is the signature and the agent who acted on his behalf, who had no authority. We know the characteristics of a liquid document. We said it must be easily ascertainable in money. In other words, the exact amount needs not be ascertainable at the time, but as long as it's easily ascertainable, there's no need for long or complicated ways of evidence to prove that it's to get to the amount owed. All right. We spoke about interest. Interest payable at the bank rate or the prime lending rate of a specified bank would not be liable for provisional sentence. Okay. So the bank, so in provisional sentence matters, the court will not consider anything other than the legal rate, legal interest rate. All right, have a look at the onus of proof on the plaintiff and the onus of proof on the defendant, and the appealability of a judge provisional sentence stage, when provisional sentence is granted. Okay, we've slightly touched on process of execution, right? Execution process as well. execution against movable property, where there's a warrant of execution against immovable property, the sheriff merely goes to, it's normally not identified property. He will go to the property of the execution debtor, where he will demand payment from the debtor on the warrant of execution. The amount is stipulated, and the sheriff will then demand payment. If the debtor is unable to satisfy the amount, the judgment, by way of payment, the sheriff will then attach sufficient movable property in the house, in the property, to the value of, to the estimated value of the debt plus the sheriff's costs. Now, attachment doesn't mean, it just means that it's not a physical process. It's merely a process of writing down an inventory of the property and then telling the debtor that this property, here is an inventory and here is an attachment notice that this property has now been attached. You may not remove it, sell it, or do anything with it or give it away. And you have 30 days within which to pay this money. Then after 30 days, when the judgment debt has not been satisfied, the attorney for the judgment creditor will then issue a notice in terms of Section 38 security. It's a Rule 38. Is it a Rule 38 or a Section 38? It's a Section 38 notice in terms of which the creditor now indemnifies the sheriff against any claim for attaching and removing. And then he will also be provided with a notice of removal after the attachment, to be able to remove the attached goods now, movable property, and to a safe place where after another 30 days, if the judgment debt is still not satisfied, the sheriff will then advertise, the judgment creditor will then advertise the property for sale in execution. It's actually 10 days. Gone are the days when sheriffs sit with property, with cars and other property of debtors for long periods of time, because the sheriff charges an amount for storage every day. So the sheriff is required in terms of Section 38 to within 10 days, well, not the sheriff, but the creditor must issue a notice of sale in execution within 10 days of the property being attached, and then place an advert in the newspaper or on the notice board of the court concerned that there's going to be a sale and execution of this property. And then on the day of the sale, parties can go to the sheriff's offices, where the property will normally be placed outside for persons to view, interested persons to view, before they bid to the highest seller on auction. That is how movable property is executed. In respect of immovable property, which is land and buildings, the rule is that the Rule 43 capital A is for the, well, for Rule 43 itself is for the attachment of immovable property. After the property has been attached in terms of Rule 43, the judgment creditor cannot merely sell the property. Rule 43 capital A provides that the judgment creditor must bring a special application to the court to have the property declared executable, specially executable, because Now it will mean, it could mean that the property belongs to, on the property, there are people residing who fall within certain categories. One such category is that there are minor children living on the property. There is a single parent, or there are single parents living on the property. The names of the persons must be put on there. The judgment creditor must disclose the names, of the persons residing on there. So the judgment creditor must actually conduct an investigation of who the people are on the property. And this is in line with the constitutional imperatives when it comes to property, the right to property. There must also be a reserve price set on the property. So there are a number of requirements which must be met in order for a party to succeed with execution of property, immovable property. But it's a cumbersome process which the creditor has to go through in order to prove that the property must be declared executable. And that is basically to protect not just the tenants or the occupants of the property. It's also to secure that in the event that the parties are unable to come up, the debtor is unable to come up with the arrear amount. It's normally in arrears for the mortgage or the installments on the property. That after that there will be a process by the new owner of the property to have to evict these people. And it happens. We know that this happens in South Africa these days, that you buy a property, it's already got a ready-made family on it, and then you struggle to evict them because certain proceedings have to be followed. But it's a long and cumbersome story. And well, Rule 43, sub-rule capital A, provides for the procedure on it. The notes are not that detailed on the process itself. The rule itself, Rule 43, capital A, is a very, very long rule itself. So go do yourself a favor and go and read up on Rule 43. It has quite a lot of requirements which have to be complied with. And yeah, you just make sure that you read through that, please. Section 65 proceedings. We know Section 65 deals with debt collection in the magistrates court. It's the manner in which you can bring a debtor to court for a financial inquiry to enable the court to make an order for payment of a debt in installments. Either the debtor pays those installments to the creditor by hand, or they agree to an emoluments attachment order, which is also called a garnishee order, an EAO. Either the debtor signs it at court, the sheriff then goes and serves it on the employer of the debtor, and the employer then deducts that money off every month and sends it over to the creditor. But here are some important features of Section 65. The debtor personally or a director or official of the debtor must appear in court on a specific date for an inquiry into the financial affairs of the debtor. The court where the debtor resides or is employed has jurisdiction to hear the matter. So there again, you follow the defendant, the debtor. In the case of a juristic person, the court in which the registered office or principal place of business is situated has jurisdiction to hear the matter. The debtor may be ordered to pay the debt in specified installments, and if it appears that the debtor's own assets that he owns assets, the court may authorize that a warrant of execution be issued. So you can ask there, if the debtor discloses at that inquiry that he has assets, you ask the court to authorize a warrant of execution. Antonia, I hope you're listening to that. The debtor or representative may be ordered to bring specified documents to court. In other words, bring us proof of your income, bring us proof of your expenditure. The people who are financially reliant on you. He may then be ordered to pay the debt in specified installments, and if it appears that he owns assets, we just said so, authorize that a warrant of execution be issued. Again, the court may also authorize an emoluments attachment order, which is the garnish order we spoke about. So the only other remedies available to the creditor are garnishee orders and the sequestration of the debtor. In other words, his liabilities exceed his assets, and you can then apply to have him sequestrated. Right. That's the procedure. Have a look at that. And when a debtor must appear in court. If a debtor fails to come to court, he may be found guilty of an offense and liable on a conviction to a fine or imprisonment for a period not exceeding 3 months. That's important to note. And by the way, previously, you could bring a debtor to court and have him arrested. But since we have a constitution now that gives everyone rights, that has since been repealed from the statute books, and no longer is provision made for someone to be arrested for debt. Okay. So if a garnishee also refuses to, an employer refuses to deduct the amount for a garnishee from the employee's salary, they may also be called to court to explain why, and the court may then issue an order against them. Right. All right, appeals and reviews. What is an appeal? You must know the difference between an appeal and a review. An appeal is a document. An appeal is the process where you challenge, where you're not satisfied with, and you challenge the outcome of a judgment, of a case. Whereas a review is where you challenge the procedure of certain proceedings. And I'll make an example. After a case has been heard, the magistrate issues a judgment, and in the judgment, the defendant is not happy with the outcome of the judgment. For instance, the magistrate says the case is dismissed with costs. The plaintiff then wants to appeal the judgment, which is the outcome, because he feels that in reaching the outcome, the magistrate made some errors. And these errors are, he did not consider the evidence of a crucial witness. He appeared biased towards the plaintiff. He also let's leave bias out. Sorry, bias applies in reviews, but during appeals, you only need to show that he made an error in arriving at the decision. During review, you can take a matter on review if you are of the opinion that the magistrate was biased towards the parties during the proceedings. He ignored crucial evidence which he should have paid attention to. Those are grounds for bringing review application, and reviews and appeals are both brought on application. Now, a proceeding that is also not very popular is that of interpleader proceedings, but it will happen where a plaintiff will institute proceedings against a defendant, obtain judgment against that defendant, and then execute on the property of the defendant. Then the plaintiff will attach and remove the property of the defendant, and the defendant will then notify Geen and Richards Furnitures that the furniture which they are still paying by hire purchase or credit agreement has now been attached and removed by the sheriff and the plaintiff in satisfaction of a debt in favor of the plaintiff. Because the defendant still owes the furniture money in respect of the furniture that has been attached and removed, the defendant now decides he's going to stop paying for it. And coming back to the rental issue, the furniture shop has a hypothec or a lien over the goods until they are paid for. The defendant then decides he's going to stop paying for it, and he tells the furniture shop, go and fetch your stuff there from the sheriff. I don't have it. In order for the sheriff for the furniture shop to obtain the right to the property, to manifest their hypothec over the property, they will have to bring interpleader proceedings. In other words, they will now be an interpleader who is now laying a claim to a better right, to have a better right over the property. The sheriff will then fill out an interpleader summons, or they will fill it out called an interpleader summons, in which the facts will be set out that the furniture shop now, Geen and Richards, now are laying claim to this property which has been attached. The matter will then go to court, to the magistrate, before a magistrate, and the magistrate will have to determine who has a better right to the other person, to the other one, in respect of the property. And then a decision will be made. Quickly then on mediation. We all know what mediation is, and nowadays, in terms of our rules, I know in the High Court, Rule 41 has specifically been enacted for purposes of mediation. And there, the courts are required, or rather parties are required, to consider mediation in matters before proceeding to court. And when a party institutes proceedings, that party must issue a notice to the defendant to tell the defendant that they have to consider mediation before the matter proceeds. And in terms of Rule 77 of the Magistrates Court rules, they have similar obligations to refer a matter to court for mediation, to refer a matter for mediation before instituting proceedings or commencing with litigation. And mediation is a less adversarial procedure whereby the matter is referred to a neutral person, an independent person, who will not be deciding on the case, but will rather be involved in a facilitative process to find an alternative resolution to the case between the parties. And I was privileged enough to do a mediation course at the beginning of this year. And the process is not as adversarial as litigation. It is much more friendly. It is much more facilitating, and it is much more emotional, because you have to deal with the parties' emotions, and there are many emotions involved, and you are dealing directly with the parties. But it sometimes becomes difficult for the parties to find each other in mediation because of the emotions and the anger. And that is most probably because of the role of legal representatives, because they don't know any other way of doing things other than being adversarial. But there's a big move there to make mediation part of our system. Please read up on mediation as well. Contingency litigation, very important. Contingency litigation is where an attorney agrees to act on behalf of a client who does not have any money to litigate, to pay fees, but who has strong prospects of success. You find that in most RAF claims, also in medical negligence cases where people do not have funds. Attorneys take those cases on spec and normally agree to a fee up to 25% of the capital sum which they may settle the claim for. For example, if it's R1 million, they are entitled to 250,000 Rand. 10 million Rand, 2.5 million Rand. But you have to follow the provisions of the Contingency Fees Act. And the courts in each case will ask if there is the Contingency Fees Act. And in that case, they will, if your contingency fees agreement does not comply with the Act, they will set it aside and you'll be entitled to your normal fee and not the contingency fee. There's a specific act, the Contingency Fees Act, which sets out everything that has to be done and how it has to be done. All right, so briefly then, have a look at the notes too as well. Heads of argument. Only in applications the parties have to draw heads of argument. The applicant and the respondent. Each party has to draft heads of argument, which are short notes on the cases that they are going to rely on, the facts in their favor, the legal principles, the law, and the argument that they're going to present, but in very shortened form. Normally, that would entail an introduction, the facts relied upon, the issues to be raised, to be determined by the court, the law they rely upon, and then the application of the law to those facts in your case, and the conclusion the court must make and why. Both parties have to file those heads. All right. Right, then you have in an action, in a trial, what happens is the plaintiff will start, depending on what the case is about. The plaintiff always has the onus of starting and the onus of proof and beginning. But there are exceptions. One such exception is in the case of unlawful arrest and detention, where the police admit that they've arrested the plaintiff. The defendant then has the onus of proving that the arrest was lawful. So it's important to know that. Whoever calls the witness first, whoever starts will do an opening statement, brief opening statement setting out what the case is about, what their cause of action is, what they need to prove, how they need to prove it, and which witnesses they will call to prove it. They then call their witnesses one by one, and each witness will be led in examination in chief, no leading questions, let the witness tell his story. The cross-examination by the opponent will take place by questions based on the evidence led in examination in chief. After that, the party whose witness it is has an opportunity to re-examine the witness, just to cover any corners or any evidence that may have been shaken during cross-examination. Then the one party closes its case and the opposite party does exactly the same with its own witnesses. After which the parties then argue closing arguments, and the court then either gives judgment immediately or reserves judgment. That then is how a trial is conducted. And that concludes our work for this week. I want to once again apologize on behalf of ESCOM for last night. And I want to thank you for your time and your attention and your questions, and for engaging on the platform and asking questions and your comments. And thank you everyone for your participation. Emily has a question. Emily wants to know, is there existing magistrate court directive? Yes, Emily, there is. Have a look at page 225 of the manual, the Magistrates Court Practice 1. That is the Civil Practice Directive for magistrates. Any other questions? Right. If there are no more questions, I'm sorry once again. I know it's 9 o'clock already on a Friday night. Good luck with your legal careers, and all the best with your other courses. Thank you once again.
Thank you.
Thanks and good night, Advocate.
Thank you, Advocate. Good night.